Good morning to all of you. Welcome to Legal Matters by Sai Babu Sukara. Today we are going to discuss regarding the PILS, public interest litigation, which is held as frivolous public interest litigation by the Honorable High Court of Andhra Pradesh. Right. So while disposing the writ petition, of course it has been posted to July 15th or so. This writ petition has been filed by Narasapuram MP Sri Kanumuri Raghuram Krishnam Raju, whom we call him as Triple R popularly. You may be knowing, daily he comes to TV5 and daily he will be giving so many political issues. He will be dealing with so many political issues. People are in favor of him, certain section is against him. So we can say he is the one MP who has not seen his constituency for the past 2.5 years or so. But whatever it is, very intelligent man. And definitely, so he has filed a writ petition, of course. On his behalf, the writ petition was argued by Shri Ambadi Sudhakar, who is from Prakasham district near Parchur area. When I worked as a police officer, he was a budding lawyer under his senior Shri Muddana Ramaya Chaudhary. He has also argued well. Right. The petition is regarding the diversion of funds in the name of AP Beverages Corporation. The government is showing the margin money as profit to the AP Beverages Corporation, and they wanted to take loan from the authorities, from the banks and other people. So because they have to maintain the so-called welfare schemes. Of course, there are political comments that the government is not able to get money. They are making so many debts and other things. That's a political issue. So here, the act was amended. Actually, the wholesale distribution and retail distribution of Indian liquor, foreign liquor distribution, the act is there. So 31 by 2021 and 9 by 2022 amendments are there. These amendments should be declared as void. Should be declared as I don't remember the name correctly. Right? They should be declared as unfitting in view of Raghuram Krishnam Raju. Why? Because the government is diverting the money. They wanted to take loan. Therefore, this margin money relating to AP Beverages Corporation, it is shown as profit and they want to take loan on that, which is not correct, which is against to the constitutional ethos. But the court remarked, "Who are you?" Then advocate said, "My client is, the writ petitioner is Mr. Raghuram Krishnam Raju, he is an MP. So he is a lawmaker." Yes, Your Honor. Then what is his duty? His duty is to raise the issue in the parliament. He is a politician basically. He has to raise the issue in the parliament. He cannot come to the court quite often and with this frivolous petitions. And second point, do you want to stall the so-called welfare programs by the government? You want to create trouble to the government in so-called implementing the welfare programs? The advocate replied, "Certainly no, Your Honor. But the thing is, the state is going into a debt trap. Then who has to look after?" The court said. So this is observed by Honorable Chief Justice of Andhra Pradesh, Sri Prashant Kumar Mishra, and Advocate Justice D.V.S.S. Somayajulu. Right? They clearly stated that the courts cannot run the governments. Courts do not run the governments, and governments cannot run the state also, courts also. Who have to run? The government has to run. So the courts will not interfere in the financial and economical affairs of a state. It is the prerogative of the Comptroller and Auditor General of India or the Reserve Bank of India to maintain the so-called economical balance or to warn the governments if they expend more, things like that, but not the court. So, and another question was put by the Honorable Court state that how the public are being affected. So here we have to differ with the court also, because even though the margin monies, the schemes are meant and the schemes are, of course, we are collecting a tax from the public. Suppose If it is going into a debtor trap, who has to pay? Definitely we, the people, in the name of tax. So to avoid that, of course, the intention of the Raghuram Krishnaraju is definitely good, but it is not the way. So please remember, the court also stated that suppose if we allow petitions like this, tomorrow somebody may challenge the budget under Article 226 of the Constitution of India. Therefore, in the opinion of the Honorable High Court of Andhra Pradesh, this is a frivolous petition, no inquiry, even no notice to the government of Andhra Pradesh. So almost, of course, the matter is posted to July 15th, and of course there may be some other arguments. If the advocate Mr. Sudhakar is able to convince the court, then they will take the matter. Otherwise, it may be likely to be dismissed. Whatever it is, please remember, here the important point is, in 1978, Justice P.N. Bhagwati and others, with the very good intention of approaching or of making the law approachable to even to the ordinary citizens, and getting an exception to the principle of locus standi, then they have created this public interest litigation. But now they have become publicity interest litigations, and they have become frivolous. Whatever false, frivolous vexation, idi niradhakamaina. So before filing the petition, you should understand whether the court is able to take it on file or not, whether the court can dispose it or not. So this is important. So this is actually taking away most of the time of the court. So it's a boon to the government also. Normally, every day we have been seeing the High Court giving passing strictures against the officers, commenting against the government, all these things daily happening. But this is very good supportive decision to the state of Andhra Pradesh. They may feel happy. What I want to tell is, don't file frivolous petitions before the court. Right? With this, I am saying bye. Thank you very much.